I think this webinar is very apt, and the timing it could not be better. The ISA is going into its session in July. It's going to be one of the more interesting sessions as the exploitation regulations, environmental regulations, financial regulations are all coming to a crux at this point. And the point of this webinar today is to try to demystify some of the things that surround UNCLOS and the role of the ISA. I hope that we will succeed in doing so, because it is a somewhat complex area, but Eleanor is probably exceptionally well placed to do that for us. She's a partner at Norton Rose. I think I should say Norton Rose Fulbright, although I'm not sure whether Fulbright still is part of it. You know how it goes with Price Waterhouse, and we never heard about Cooper for a while. So this is Eleanor, who has also been very helpful. We've worked together on, for example, Blue Minerals Jamaica, the sponsorship agreement there, and we have been at conferences together on several occasions where Eleanor has spoken, and I've had the privilege of doing the same. So without further ado, let me pass it on to Eleanor Martin, and please make her feel welcome, and be very interested to see what she has to say.
Eleanor, did we get you back?
You've got me back.
There she is. Yeah. All right.
Excellent. Okay, great. Apologies for that. At the prime moment, my internet decided to cut out, but I'm back. Thank you very much, Peter, and thank you very much to Impossible Metals for hosting today and having me on. So good morning, good afternoon, good evening to all of you. My aim today, as Peter said, is really to demystify the International Seabed Authority and the UN Convention of the Law of the Sea. And I must admit, without any shame, I am a transactional lawyer. So I'm not going to sit and talk to you about policy and esoteric ideas. I'm actually going to talk to you about how the regulations work for concrete actions. And for those of you who don't know Norton Rose Fulbright, we're an international law firm. We've got offices in over 50 countries. So although I'm based in London, I'm currently coming to you from our Houston office because I'm traveling and speaking with colleagues and clients here. And our main industry areas that we like to focus on include mining, but also shipping. So deep sea mining is something that we've been following for a number of years. And as Peter mentioned, we've been helping a number of clients really get their heads around what's going on and get into action in order to be able to start seabed mining. So with all of that said, what are we going to run through today? Let's see if I can get my slides to work. Great. So I'm going to take you through a high-level view of the legal framework, talk to you about some of the ways that decisions are made in respect of deep sea mining, because I think a lot of people think it goes into some sort of black hole, but it's helpful to understand how that actually works. Then also look at the role of the sponsoring state and what that actually means, the licensing regime as it is today and as it might be in the coming future, and then a quick look at what will happen next. And I should say that I'm very happy to take questions at the end, and if you would like to pop them into the chat box, then please do feel free to do so, or alternatively, we can come to questions at the end. Okay, so what are we talking about? And I don't profess to be a technical expert, but there are three types of resources that we're talking about when we discuss seabed mining. The first is the polymetallic nodules, and these are small sort of potato-shaped rocks which lie on the surface of the seabed and can essentially be picked up. And they are several different minerals and metals smelted together. So the process for production involves sort of smelting those off and finding each individual commodity. We're also going to consider polymetallic sulfides, which are shown on the right here. And these are essentially formed by what I like to call volcanoes under the sea. And the mining process for those involves essentially slicing off those bits of rock that sit up, and then again the smelting process to find the valuable resources therein. And the third type is the ferromanganese crusts. So these are crusts that are formed on the seabed themselves. They're actually very well connected, unlike the polymetallic nodules. And these can be mined by scraping them off the bottom of the rock, and then again going through a processing process. So who can harvest these minerals and under what regime? And that really depends on where they're located. So this is quite a complicated slide, but essentially what it shows you is in grey, the different countries, in white, the areas around those different countries called the exclusive economic zones. And I'll come to explain what that means in a moment. And then the minerals that we know about, and you'll see that this is actually slightly out of date because it's from 2018, so it doesn't show the recent reserves discovered around Norway. But in blue, you'll see the polymetallic nodules, and you'll see they're primarily concentrated in the Pacific Ocean. In orange, you'll see the polymetallic sulfides, and then in yellow, you'll see the cobalt-rich crusts or ferromanganese crusts. So who can harvest what and where? And this is regulated by the UN Convention of the Law of the Sea, which came into force in 1994 by way of an implementation agreement. So this is an international convention, which means that individual states sign up to it and ratify it. So essentially agree to be bound by that convention. And the UN Convention of the Law of the Sea is widely viewed as one of the most successful because it's got 167 member states who've signed up, as well as the EU. There are some conventions that get circulated for signature and ratification and never actually receive the force of law because not enough people sign up to it. So the UN Convention is very much seen as one of the most successful. Many member states, as I said, but a key element to note here is that the US has not yet signed up or ratified the UN Convention, although the wider view is that it tends to respect its provisions. And the UN Convention clearly states that the area that's 200 nautical miles from a coastline basically belongs to the country who has that coastline. And that is what we call the exclusive economic zone. So, for example, I mentioned that around Norway, there have been cobalt-rich crusts found. And Norway has, earlier this year, passed its own legislation allowing for the potential to mine its seabed in its domestic waters, and has launched its first license round, which is ongoing at the moment. And other sort of areas where there are potential resources that are well known and documented are the Pacific islands, for example, the Cook Islands and Tonga, and they have also passed their own domestic legislation to enable mining in their domestic waters. The Pacific Islands in particular were supported by the UK Commonwealth, so a number of those statutes are surprisingly similar. Now, that 200 nautical mile rule is often open to interpretation and involves quite a lot of technical data, because to the extent that land extends underwater, that 200 nautical mile radius can be extended. And recently, the US made a declaration as to where they considered that their domestic waters started and ended, using certain underwater channels. And it's widely thought that they did that just to make sure that they knew where their rights to mine domestically stopped and started, with a view to securing critical minerals going forward. So that's domestic mining, which, as I say, is regulated by each country under their own jurisdiction. But what about all of those minerals that we can see that are really outside those white areas on this map? And this is considered, these areas of the sea are considered by the UN Convention of the Law of the Sea to be the area. And the area is to be administered for the benefit of all mankind. Now, this is a concept that you see in a lot of UN conventions. It's very much used in space conventions, for example. So it essentially means that whatever is there should be for the benefit of everybody, not just one private contractor or one certain country. So this means that the mineral deposits that are found outside of an exclusive economic zone in the area are controlled and legislated by the UN Convention of the Law of the Sea, and their administrative body is the International Seabed Authority, or the ISA. And it's important to note that all state parties that have ratified the UN Convention are the member states of the ISA. Now, the ISA would not be able to function if all decisions that it took were taken by 167 plus member states. So there are several sort of organs of the ISA which serve to assist with the administration of the UN Convention. And it's split into the Assembly, which comprises of all of those member states, the Council, which comprises of a smaller number of member states on a rotating basis. And they have two key elements of that council. The first is the Technical and Legal Commission, and the second is the Economic Policy Commission. And then as well as that, they have the Secretariat, which really is an administrative role. So the UN Convention contains a general framework for deep sea mining. And in some cases, it's really written on a very, very high level in terms of policy and ideas. But in other senses, it goes into surprising amounts of detail. So it's really balancing those two sides to a convention, which is trying to be as detailed as possible, but clearly needed to get consensus between a number of different governments in order to be able to come into force. So what it provides is that essentially the ISA, together with its members, can put into place regulations, procedures and rules which really flesh out some of those high-level principles. And it's these separate regulations which are really the key to seabed mining. So at the moment where we are is we have regulations in place for prospecting and exploration, particularly for polymetallic nodules. There are different rules and procedures that apply to different types of minerals, but here we're just going to focus on polymetallic nodules because that is considered to be the most advanced of all of the seabed mining at this point in time. And what these exploration regulations allow for is for people to attain the ability to have exclusive rights to certain parts of the area and the ability to explore and take samples for analysis, build an environmental base model, for example, looking at what's there, and generally reserve that area for themselves. And these last for 15 years. And the real challenge, however, becomes in being able to actually go ahead and harvest those minerals on a commercial level. And the sets of regulations for exploitation and the rules and procedures have essentially been around in draft form and under discussion for almost 10 years now. And it's those regulations which are eagerly awaited by the whole community in order to be able to start commercializing operations. Now, the draft regulations for exploitation, as I mentioned, have been published, and most recently, following an ISA working group session, updated parts have been published which go into a lot of detail on things like the environmental aspects and also the royalty regime. And just going back to that concept of the fact that minerals in the area are for the benefit of all of mankind. The way that the royalty regime is set up is that if you are able to harvest in the area and you are essentially doing so on a commercial basis, then there should be some payback for all of mankind, which is essentially a royalty payment to the International Seabed Authority, which is then to be administered for the benefit of all mankind. So it's probably worth then turning to who can apply for these exploration licenses at this stage and who can apply for the exploitation licenses once those become available when the regulations are in place. Well, the UN Convention of the Law of the Sea is a treaty which, as I mentioned, is signed up to by governments or states. So it's not actually directly binding on people or private parties. So it allows for 3 different types of license holder. And these are the states themselves. And you'll see from this slide that we do have a number of states who have had exploration contracts awarded to them, with Russia and Poland being potential ones there, together with India. The second type of applicant can be something called the enterprise, which is a concept enshrined in the UN Convention of the Law of the Sea and is essentially meant to be an International Seabed Authority body, which is existing for the benefit of all mankind. Now, to my knowledge, that option has not yet been utilized. But the third type of applicant can be private companies. And on this list, you'll see there are a number of those in place. So how does that work if the UN Convention of the Law of the Sea doesn't actually bind people, it just binds governments? Well, in order for a private company to essentially be able to obtain one of these exploration contracts, and hopefully in the future an exploitation contract, it's required that if a private entity makes this application, it has a state which is party to the UN Convention of the Law of the Sea that stands behind it and essentially sponsors it or guarantees its obligations and takes responsibility for whether that private entity complies with the UN Convention of the Law of the Sea or not. So the way this normally works is most sponsoring states, they pass their own legislation, and what they have to show is that they have effective control over that private entity. So more often than not, but not exclusively, that private entity will be a company that is formed in the same jurisdiction as the state party. So it would be bound by their domestic legislation on how you could mine in the area. And then there is also a contractual agreement between the sponsoring state and the private entity, which sets out the rules that that private entity has to comply with, and perhaps what the sponsoring state wants back in return. So that might be royalty or tax payments. It might be training obligations for developing people within its nation in order to be qualified or trained up in deep sea mining, and various other aspects that are important to that sponsoring state. So that means that the private entity, and as you'll see, there are a number on this list, who has obtained an exploration contract, has done so with a sponsoring state who has essentially made that private company agree to be bound by the terms and conditions of the UN Convention of the Law of the Sea and any other terms that that sponsoring state wishes to impose. And you'll see from the next slide that there are quite a few sponsoring states, with China and Russia being particularly prevalent, but a number of the Pacific Islands are also included there. So we've touched a little bit on the licensing regime and the process. And you'll see that a number of states and contractors are through the first round of licensing, i.e. they have those exclusive rights to explore in certain parts of the area. And the process it is perhaps not as difficult as some might expect. So it involves putting forward an application and the payment of a fee. And the application has to cover a number of different aspects. But the proposal is then considered and a decision is taken by the council, which, as I mentioned, is a smaller group of states. And after that, a contract for exploration is issued. And these are public and publicly available on the ISA's website. And as noted, although the draft exploitation regulations exist, they're not yet in full force and effect. So they've not yet been approved. And the process for this approval is actually quite key, because the way that the UN Convention of the Law of the Sea is structured is that it really seeks to obtain consensus from all of the different state parties. So they're really looking for 100% of them to agree to the draft exploitation regulations. But in the absence of that, a decision can be taken by 2/3 of the member states who are present and voting. And it's that element that we think is most likely to be utilized in passing the exploitation regulation. And this is important as we start to look at the next steps, really. Because as you'll see from the timeline on this slide, things can move somewhat slowly. We know that the first exploration contracts were issued in 2001. We know that they're for 15 years, and therefore we're really coming up to the point at which some of those may start to expire, which creates a very, very natural deadline for getting the exploitation regulations in place and enabling some of those contractors to really start applying for their exploitation licenses. You'll see that in 2015, the draft exploitation regulations were first published for consultation. As I say, for nearly 10 years now, those have been discussed a number of times. And then something happened in 2021, July of 2021, which was the government of Nauru basically issued a request for those regulations to be put in place. They did this using a provision under the 1994 implementation agreement. And that requires the International Seabed Authority to adopt rules, regulations, and procedures within 2 years of their request. And their request was very strongly to have the exploitation regime in place. Now, that deadline has now passed. And the position, therefore, under the UN Convention of the Law of the Sea, is that the ISA must consider any application for exploitation and provisionally approve it. And there are a number of different debates and conversations around what provisional approval means, whether that means that actually they're bound to approve an application and exploitation or harvesting on a commercial level can really start to go ahead, or whether it means that they can provisionally approve it, but subject to getting the exploitation regulations agreed. And it's worth noting that there are meetings to discuss the exploitation regulations scheduled in a month's time and further thereafter. So I think the Nauru triggering of the so-called 2-year rule, as it's known, has really accelerated some of the discussion around the exploitation regulations. We're not there yet, but there's certainly a lot of focus on getting those regulations in place. So although I don't intend to go into the politics of it, because that could take a very long time, there are a number of member states who are expressing concerns and potentially calling for a moratorium or a precautionary pause on exploitation in the area. There's also a number of private companies who have called for this, such as the car manufacturers. So BMW has been quite vocal about this, saying that it won't use any minerals produced from the seabed in any of its future manufacturing. But it's important to note that these calls for moratoria or precautionary pauses are very much couched in environmental concerns, but until such time as those environmental concerns can be addressed in a way which gives people comfort. So it's really calling for a moratorium until such time as we know more about the environmental impacts of seabed mining. And that's why there are a number of companies, Impossible Metals included, developing concepts for really ensuring that the harvesting of these minerals are done in the least environmentally impactful way, if I can put it that way. So really that brings us back to the voting regime in terms of passing these exploitation regulations. As I mentioned, it's not a requirement that everybody agrees. It is a requirement that 2/3 of those present and voting agree. And that's really the next step in the process for ensuring that seabed mining becomes more of a commercial reality and people can take a step towards exploitation. So that was actually all I was going to cover today. I appreciate it's been quite a high level. And so I'm very happy to take questions to the extent I can. And if not, then certainly follow up with individuals. So Holly, I'll pass over to you if you would mind marshalling the questions for us.
Not at all. So excuse me, I'll kind of, we'll start with the 2 questions in the chat and then we'll move on to raised hands. So Eleanor, did you want me to read them out loud or do you want to just respond to them directly?
No, that's great. I can go ahead. Thank you. Okay, so the first one I've got here is which sponsoring states have made their own national regulations for deep sea mining? There are a number of them. As I said, the Pacific islands have been particularly active in this area, but the UK, for example, has passed their own national regulations. Norway has recently passed theirs, and it really is a case of looking at where those resources are and working out who will be next to pass their own legislation. And then the next question I've got here is, how are the royalties collected by the ISA utilized for the good of mankind? Are specific measures, projects active to achieve this goal? That's an excellent question. I actually don't think anything in particular has been published on this yet as to how the ISA are going to administer these. There are a number of provisions in the UN Convention of the Law of the Sea which should suggest that the ISE has a role in assisting developing states or developing countries, and in addition assisting countries that are landlocked, so don't actually have their own area for mining in their domestic waters. So I predict that actually that would be probably an area that the ISA would look at once it starts to collect those royalties. And the royalty regime is something we've been involved in, and it's becoming more and more complicated as time goes on and as different stakeholders input into the royalty regime. One of the elements that was introduced in the last session was really a tax equalization measure, which essentially aimed to try and ensure that if, for example, an entity is sponsored by a state which has certain tax incentives on deep sea mining, then it shouldn't be treated or it shouldn't be better off than another entity that doesn't have those tax incentives in its sponsoring state regime. So there are constantly tweaks that are being put into place in relation to these royalty regimes, and it's something that we're very, very keen to have nailed down, because we think that that is the key to unlocking the commercial viability of deep sea mining, particularly in the area.
Great. Let's jump over to Jim, who has raised his hand.
Hello, Eleanor. Can you hear me?
I can indeed. Thanks, Jim.
Okay. I was wondering about how the ISA, which is a UN body, interacts with other UN bodies. And I guess more specifically, do you know whether the IMO recognize the sponsoring states for the regulations controlling the shipping of bulk materials such as nodules?
That's a great question, and actually, it's something that came up recently in the concept of this concept of effective control, and the reason it's become quite important is because Lockheed Martin held 2 licenses in the area for polymetallic nodules, and because they're a US company and because the US hasn't ratified the UN Convention for the Law of the Sea, those 2 licenses were held by 2 UK subsidiaries and sponsored by the UK government. And Lockheed Martin has recently sold those shares in those 2 UK subsidiaries to a Norwegian company, Loki Minerals. And so this concept of effective control has come up and been discussed on a number of different levels, i.e., can the UK government effectively control a UK company which is owned by a Norwegian shareholder? And the reason I bring that up is because they looked to how the IMO looks at the concept of effective control, for example, for flagging of vessels. And it's quite well settled within shipping law that it is possible for vessels to have a flag or to be registered in a country which doesn't have any other nexus to that ship or to that company, so-called flags of convenience. So yes, I think there are discussions between the different sort of UN bodies, and they're taking sort of positions and information from each other. But I am not privy to those. So that's just based on sort of the discussions that I've had.
Yeah, I guess there's the codes such as the IMSBC, which will cover the shipping of bulk materials, refers to the state of the port of loading, which would be the sponsoring state, and nobody knows whether the sponsoring state would be UK or Tonga or Belgium or whoever. So anyways, I don't want to sidetrack the discussion because I know there's lots of other questions, but it brings that whole question of, what is the definition of a sponsoring state with respects to whole other, codes and standards and regulations for building things and all that kind of stuff. But yeah, lots of questions. Thanks very much, Eleanor, for a good presentation.
Thanks. Completely agree. Thanks, Jim.
Great. Eleanor, let's jump back to the chat. We've got a few questions in there.
Great. So I think the first one I've got here is recently Worldwide Fund for Nature, WWF Norway, filed a lawsuit against the Norwegian government. How significant, impactful can this be in slowing down the development? Another great question. You're absolutely right. The Norwegian environmental lobby has been very strong and vehement in their dislike for this pathway that the Norwegian government have taken. The EU Parliament also issued a statement to the Norwegian government expressing its dismay at Norway choosing to go down this route. I think the reality is that Norway are continuing to really move forward on this basis, and so I suspect that there will be significant issues that they will need to overcome, but from the discussions that I've been having, certainly they are very much with their eyes on the prize, so they are continuing forward. And I think the response that they will give is that, you know, this will be properly regulated and very well organized in the same way that they have done for their oil and gas industry. But they are certainly moving forward despite the EU and other environmental lobbyists very much expressing their dismay. Okay, the next one I've got here is there specific or preferred technical requirements for collecting methods, and what measures does the ISA use to assess environmental impact of equipment used to collect nodules and bring them to the surface? Another great question. So that is a whole other working group within the ISA in terms of the environmental impacts of how you harvest these nodules. There are a number of different processes that are under discussion. And as I say, I'm not a technical person, but from a layman's terms, there's ones where you essentially sort of hoover or vacuum up the nodules from the seabed. And the concern about that method is that when you sort of suck up the nodules, you also suck up the surface of the seabed, and how that can then be released back into the ocean, and whether that causes a plume, which is essentially sediment in the ocean, which can travel a significant distance. The other sort of way of doing things is the one that Impossible Metals have set out, which is essentially choosing the nodules which are not part of any sort of coral or don't have anything living within them, and then taking those up to the surface. So a less invasive potential method of harvesting. So those are the two that are currently being looked at. But one of the elements of the UN Convention for the Law of the Sea and the draft exploitation regulations, it really focuses on the environmental aspects. So there's an environmental plan that needs to be set out. There's an environmental baseline that needs to be set out. And the ISA has a number of inspection rights to make sure that, you know, what is being said is actually being followed. And there is also an environmental guarantee, which is either in the form of some sort of deposit or performance bond from a creditworthy entity, which can be called upon basically if one of those contractors doesn't follow its environmental plan and does cause damage, as well as the ability to obviously take away its rights to exploit in the area. So that is well versed, but as I say, as the subject of a separate working group. And the general overriding principle that the ISA goes by is the precautionary principle. Okay. So the next question here I've got is, my understanding has been that the area's UK seabed resources under contract with the ISA did not overlap with Lockheed's USA 1 and USA 4 exploration licenses. Lockheed still retains 2 exploration licenses. Okay, I cannot comment on that, I'm afraid, as to what they do or they don't have. I just do know that their UK seabed resources have been moved. Thanks, Rahul. I'll certainly put my email address on screen so that you can see that. Thank you very much. The next question is, Article 1618 of UNCLOS provides that regulations for exploitation must be adopted by consensus at the Council, and goes on to provide that consensus here means in the absence of any formal objections. Could you clarify what you mean by 2/3 majority vote could suffice? Yes, I'm talking about here where there's an issue of substance. I think it's Article 159, which essentially allows those points of substance to be decided by the 2/3 rule. There was a statement that was made, and I think it was back in July 2023, by the ISA after a formal meeting, that there was consensus on moving forward with the exploitation regulations, and therefore there's potentially the argument that using that 2/3 majority rule could work. Okay, The next one here is how many vessels are ready to start harvesting, and what does the banking sector think about investing in deep sea mining? Great question. So in terms of vessels that are ready, we know that Allseas has the Hidden Gem, which is pretty much ready to go. And we do know that a number of contractors have been entering into strategic partnerships with a number of shipping companies. But in terms of vessels being ready to go, that I can't comment on. I would expect there are a number of people who are closely following this. And of course, there are a number of issues to consider, particularly in the area, which is off the coast of the US. And there are Jones Act considerations in particular about which vessels can operate in that area. In terms of the banking sector, the views here are quite mixed. So we have been recently having a number of incoming queries from banks and funds who are actively looking at this area. They understand the need for these resources for energy transition purposes, and they can see the business case and the business model for going ahead. The key to unlocking the banking sector's appetite for this is really understanding the royalty regime process, and therefore you know, how much things would cost and how much is a return on the capital available. But a number of the banks who are active in mining and shipping are really looking at this. And I should mention there is an added factor here, which is that a number of the banks have a certain pots of cash which are available for green or sustainable financing, and they're unable obviously to deploy a number of those to certain projects that they would traditionally have supported, such as the oil and gas industry. And therefore deep sea mining really presents an opportunity here because it is in support of energy transition. I think that's all the questions I can see at this stage. Oh, Becky, you have a question. Go for it.
Hi, Eleanor. Thanks for the great presentation. I have a couple questions, but they're really more kind of about your maybe opinion on how things are going, and you know, if that's not something you want to provide, no problem, but I can ask anyway. So my first question is on the environmental threshold values that are being put in place. So there's the working groups who are working on the environmental threshold values, and I think this is kind of this is an important piece for everybody at the table who's looking for that. What is the number for what significant impact means, right? So I know that the working groups were established. You know, there's like 3 things that they're looking at. I was just wondering if you know sort of like what the status of that is. Are they discussing them at the upcoming meeting? I'm just curious.
Yeah, no, completely. So after the last session, which was back earlier this year, there were some updated proposals that were published, and I don't know off the top of my head whether those included anything on that threshold. So I suspect that they will be very much on the agenda in July. So it's definitely a watch this space, but I don't know if any of those proposals cover your point or not. I'd need to refresh my memory on what they published.
Yeah, I think maybe I should go through that what they published to see if I can find it. My other question is sort of related to something that Jim brought up earlier about the interaction with the IMO. There's also the I can never remember the long term for it. The BBNJ, the biodiversity agreement that was from 2016, and it doesn't have enough ratifications yet, right?
Yeah.
They have 7 and they need 60, right? But the ISA put out a paper about sort of how they would support the activities or requirements of the BBNJ. And it does in it have a bunch of language about like, this is unclear, this is also unclear, this is our understanding of this part. So from the ISA's perspective, they're like, we are carved out, we are, whatever we're doing is already in place, there's language that says that has to be respected. But I'm curious, from your knowledge of how this is played out in other areas, how that interpretation from the ISA may play out in real life, if they'll actually be as carved out as they interpret themselves to be, or if you anticipate there's going to be some conflict there.
Yeah, no, that's a really good point. And I think it remains to be seen is the short answer, which is probably a bit of a cop out. So sorry about that.
No, that's okay.
But it is intriguing to see that they've actually made a statement about it, and as you say, it's not yet in force, and it may never come into force, right?
True.
And I sort of come back to the UN Convention, which, as I said earlier, in some cases it's really, really high level and just concepts and ideas, and in other cases it's quite prescriptive. And my view is it's quite prescriptive about seabed mining. Like the sort of framework is really there, and there is the ability to amend the UN Convention of the Law of the Sea, but they're kind of like, that takes a significant process and a significant number of state parties. So whether they'll go down the route of, hey, well, the UN Convention of the Law of the Sea was here first, I don't know, but that would be kind of my sense of direction at this point in time.
Yeah, so they were there first, so we need to respect it. I'm almost wondering if it's going to be yes and, right? Like, yes, those are the requirements, and we're also adding on these requirements. Yeah. Because to change it would be a lot, but to add on, we'll see. Okay, thanks, Eleanor. Sorry for the sort of very detailed questions, but they're the ones who've been on my mind lately. Thank you.
No problem at all. No problem at all. And I think the point that I would say, and this is my opinion, is that, you know, with Nauru triggering this rule, there really is an impetus now on the ISA to get these exploitation regulations in place, because otherwise they run the risk of people forming legal arguments that they can just go ahead and do it, right? They've given the ISA enough time to get these detailed regulations in place. They haven't done it. They've triggered the 2-year rule. There is now the right to request to make a start. And there is the balancing of having something in place, even if it's not perfect, against not having anything in place, that I think must be quite prevalent in the minds of the International Seabed Authority and its member states.
Great. Eleanor, we have a question in the chat. We could go to that, and then Josh, will get to you after the question in the chat.
Great. So the question here is, what are the views of the insurance companies on seabed mining? That's a really, really good question. And it's not something that I've explored with the insurance companies. Obviously, they're very used to insuring vessels that operate all over the world. But as far as I'm aware, there have been no carve-outs that I've seen. But it is something that they'll definitely have to start looking at. But that's a great question. I haven't engaged with the insurance companies, and maybe we should be doing a little bit more of that.
Thank you. All right, Josh. Excuse me.
I always put my hand down instead of unmuting. Hey, thanks for the presentation, Eleanor. So one question was, in making these environmental threshold values and putting them forth for like agreement, is there a timeline that has been set in place for making those decisions and making them available to companies so that the companies know what to target? Or is it more of a conversation with these companies? Because my fear all along has been, like, if Impossible Metal Say doesn't get there fast enough to demonstrate what is a low impact, the companies that are in the race already are using, or like say using dredging technology, will then define the standard of what like the minimum environmental impact is. So is it that they're going out to find what the minimum impact of the current technologies are as the standard, or is it that they're coming from the other direction to say what can the environment handle and having that as the bar? Those are two very different things.
Yeah, and that's a really, really good point. And you're absolutely right to mention that in terms of timing, because unfortunately we're in this position where we don't know when those exploitation regulations and those guidelines and policies and procedures will actually be put into place. But what I can say is that once those are passed, so let's say that the environmental threshold is set at something which perhaps is more environmentally impactful than can be shown by impossible metals, there is the ability to issue further sort of rules and policies and guidelines, updating and or supplementing what's already in place. So it is possible that even if a threshold is set that might be considered too high, that could be changed in the future, which essentially could mean that a number of contractors might need to look at how they can change their practices.
Awesome, thanks. I imagine that might be a difficult process, especially if let's say like a member country is now profiting from a technology. Would
Completely.
Like is it that's what I'm wondering. Yeah, if there's kind of like a mass of, let's say, member states who would then say like, no, we're making money from this already, we don't agree to change regulations. Is that something that like 2/3 rule can do, or is that something that you'd have to have everybody agree on again?
So I'd need to refresh my memory on whether certain changes to, depends if it's sort of guidelines or whether it's kind of full-on exploitation regulations, how those policies and procedures need to be decided amongst member states. But it's a really good point in terms of, you know, there will then be political pressure from those states that are profiting. What I would say is that the potential to lower the threshold could make the financing community much more interested in financing these exploits. So it may have knock-on effects in another way, if you see what I mean.
Awesome, thank you.
You're welcome.